Morning, everyone. Thank you for joining us. Good morning if you're in the Pacific time zone, but I know that we have people who have signed up all across Canada. So good afternoon to those of you further east, and thank you for joining us for a webinar about the Office of the Ombudsperson of British Columbia's most recent systemic report, Alone, the Prolonged and Repeated Isolation of Youth in Custody. I'm joined today, I'm Jay Chalk, I'm the Ombudsperson in British Columbia, and I'm joined today by Zoe Jackson, the Manager of Systemic Investigations, and Sarah Milan, an Ombudsperson officer who was the lead investigator on this investigation and report. The report's the result of our investigation into the use of separate confinement in youth corrections in British Columbia. This involves youth remanded in custody until their trial, or who are found guilty and sentenced to a custodial term under the Youth Criminal Justice Act. The YCJA is a federal law administered by provinces and territories across Canada. This report is about the experiences of youth involved with the criminal justice system. They're, as I said, youth remanded in custody or awaiting trial, or who are sentenced. We also want to acknowledge the young people who have been in custody, especially those who've experienced and survived the harms caused by separate confinement. We've learned from their experiences, and we hope that telling part of their stories in this report will help lead to long-term structural and systemic change that will prevent other youth from experiencing the psychological harms caused by separate confinement and other forms of physical and social isolation. In this webinar, we'll be discussing topics related to separate confinement and the use of force in youth custody that may be upsetting to you. And for those who have been involved in the criminal justice system, the content of this report may recall or surface memories of traumatic personal experiences or experiences of families or friends. And if you require emotional support, we encourage you to reach out for help, and we have some resources that we will provide at the end of the webinar. With that, I'm going to turn it over to the Manager of Systemic Investigations, Zoe Jackson. Zoe?
Thanks, Jay. Hi, everyone, and thanks for joining us today. I'm joining you from the traditional territories of the Lekwungen-speaking people, the Esquimalt and Songhees First Nations, and that's also where our office is located. So I'm going to talk just a little bit about our office to kind of situate the report and the work that we've done. So there's a really great Supreme Court of Canada case from the 1980s that had a lot to say about the appropriate role of the Ombudsperson in providing oversight to government. And one of the things that it said that's particularly appropriate to this context, I think, is that we shine a light on places and practices that might otherwise be hidden from view. And we do this by conducting investigations. So we receive complaints from individuals, including from youth in custody, which we investigate. But we also conduct broader systemic investigations using the Ombudsperson's own motion authority, which gives us broad powers to investigate matters that we determine are important. And where necessary, after an investigation, either of a complaint or a systemic investigation, the Ombudsperson can make findings and recommendations. So those findings are findings of unfairness. They're based on our legislation, and we can make recommendations to fix the problems that we have identified. And where it's in the public interest, the Ombudsperson can issue a public report. And this is really important because our recommendations aren't binding. They will, having them implemented requires persuasion, and what the Supreme Court of Canada was also referred to as marshalling public opinion behind appropriate causes to advocate for the fair administration of public services. And just the last thing I wanted to touch on was that we promote accountability by monitoring and reporting publicly on the implementation of recommendations. And now I'm going to turn it over to Sarah, who is going to take you through our investigative work and some of the key findings that we made in our report.
Great, thanks, Zoe. Before I get into some of our key findings, I'm going to touch on some key background pieces. Megan, if you can move to the next slide. Right, so the first question, sort of one of the fundamental questions, is what is separate confinement? Separate confinement is a term that is used in BC youth custody to describe the physical and the social isolation of an individual youth away from other youth in a custody center. Now, there's other terms that are used in different prison contexts. For example, with adult populations or in other jurisdictions, terms we hear like solitary confinement, segregation, secure isolation, administrative segregation, restricted housing, secure de-escalation. All of these terms, like separate confinement, describe the practice of isolating an individual prisoner from other prisoners in the jail or custody setting. Now, regardless of the term that it's used, this practice is really defined by that isolation in a way that reduces meaningful social human contact to a level that many people, many of us, will experience as insufficient to sustain our health and well-being. The medical research is clear that this kind of social isolation is known to cause significant and sometimes irreversible psychological harms, as well as exacerbating existing trauma and mental illness. And we also know that the risk of harm that this kind of isolation causes increases over time. In British Columbia, the use of separate confinement in youth custody is governed by a regulatory framework that's set out in section 15.1 of the Youth Custody Regulation. The regulation authorizes staff to separately confine youth from other youth within a custody center. And this is really what our investigation focused on. How is separate confinement being used? How is it being experienced by youth? How frequently is it happening? How long is it happening for? What are the conditions of that confinement? Who is being impacted? And why is this happening? Next slide, please, Megan. So one of the other key background pieces is looking at who is in custody. So first of all, we see a high proportion of youth in remand in custody, even though there's been a decline in the total number of individual youth in custody over time. Remanded youth still represent about 65% of the daily average of youth in custody on it. The daily average of youth in custody. We also see an overrepresentation of Indigenous youth in custody. Now, the overrepresentation of Indigenous people in the Canadian criminal justice system has been well documented for decades, and the Truth and Reconciliation Commission discusses the complex causes of this overrepresentation. This includes the intergenerational legacy of colonialism, trauma of residential schools, and systemic discrimination that exists within the criminal justice system. We see that played out in youth custody in British Columbia, where we see the proportion of Indigenous youth increase over the last 2 decades. 20 years ago, in the fiscal year 2000 and 2001, the proportion of youth in custody who the ministry identified as Indigenous was 27%. And as you can see here in the slide, figure 4, 10 years later in 2009, 2010, this proportion grew to 42%. And 10 years later, in 2019, 2020, Indigenous youth account for 49% of all youth admitted to youth custody. This, of course, is in comparison to the proportion of Indigenous youth in the BC population as a whole. In the last federal census in 2016, approximately 10% of youth in British Columbia between the ages of 10 and 19 identified as Indigenous. These proportions are the same for male and female youth. That is that approximately half of the male and half of the female admissions to youth custody are currently Indigenous youth. Of particular note to Indigenous youth in care of the ministry are increasingly overrepresented in custody. And as you can see in the slide, 10 years ago, 2009 to 2010 fiscal year, 12% of youth admitted to custody were Indigenous and in the care of the ministry. This too has increased over time. 10 years later, 2019 to 2020, 29% of youth admitted to custody were Indigenous youth in the care of the ministry. Can you move to the next slide, Megan? I'm going to move next to our key findings. These findings emerged from our review of primary records from the Ministry of Children and Family Development, and we reviewed every instance of authorized separate confinement at Burnaby and Prince George over a 3-year period from January 1st, 2017 to December 31st, 2019. That was 307 individual instances of authorized separate confinement. And so first I'm going to describe what we saw around how often youth are separately confined and also for how long they're separately confined for. So over time, we saw that the number of instances of separate confinement at both centers declined, and that it has been declining over time. How much by? In 2012, for example, there were 570 instances of separate confinement in that year period. This has declined over time. So in the 2017-2018 fiscal year, there were 133 instances of separate confinement. And in 2019-2020, there were 72 instances. So despite the decline in the number of instances of separate confinement, we saw that the total number of hours increased. And we saw that this increase in time or duration of separate confinement is concentrated in Burnaby. In other words, there were less instances happening, but youth were being separately confined for longer periods of time. Over the same period of time, the number of hours of separate confinement declined in Prince George. So they saw both a decline in the number of instances, whereas the average duration of separate confinement stayed about the same. When we looked at who was being separately confined with respect to both frequency and also duration, we found that Indigenous youth were separately confined more frequently and for more total hours than other youth. We also found that Indigenous youth experienced far more prolonged periods of separate confinement that lasted over 72 hours. Now, this distribution of time, of hours of separate confinement is shown here in the slide. These three colors, the purple, the blue, and the orange, are grouped in duration periods of shorter periods of separate confinement, that lasted between 1 to 3 days, and then the orange bars represent separate confinement that lasted for 72 hours or more. You can see how Indigenous youth here are vastly overrepresented in the total number of hours, but also in the prolonged periods of separate confinement. Now, looking at gender, we found that male youth were separately confined most frequently, but female and gender diverse youth were separately confined for much longer periods of time. This increase in hours and in the prolonged periods of separate confinement raised concerns for us because the research is clear that the risk of psychological harm from separate confinement increases over time. We can move to the next slide, Megan, thanks. So given the risks of harm from these prolonged periods of separate confinement, we looked very closely at all the instances of separate confinement that lasted over 72 hours. We tried to identify what kinds of risks these long periods of separate confinement were being used to respond to, and also to try to understand who is experiencing these prolonged periods. You can see on the slide here, we've mapped out all the instances of separate confinement. Now, these are just the instances that were over 72 hours or longer. There's 32 in total. The colors represent the type of risk that the separate confinement was used to respond to. The purple color is coded to self-injury. The green is coded to suspected contraband, which is really the risk of drugs coming into the center or being held in possession while in the center. So you can see here that youth who were self-injuring or who were suicidal were separately confined for the longest periods of time. And when we look at more aggregated total hours, we can see that again, the greatest number of hours was in response to youth who were self-injuring. We found that 64% of the total number of hours of separate confinement over 72 hours were in response to youth who were self-injuring. We can move to the next slide. So we tried to understand who is experiencing these long periods of separate confinement. As we can see in the figure on the slide, female and gender diverse youth experienced almost 95% of the hours of these prolonged periods of separate confinement. 65% of these hours were experienced by Indigenous female youth. In contrast, white female youth experienced no more than 4% of these hours, and non-Indigenous male youth experienced none. In conclusion, we found that separate confinement in response to self-injury was experienced primarily by female youth, mostly Indigenous and racialized female youth. And we also found that 3 individual youth, 2 Indigenous female youth in the care of the ministry, and 1 racialized non-binary youth were separately confined far more than any other youth. These youth were confined repeatedly over our 3-year investigation, with some of the very longest periods of separate confinement lasting for 38 days, 41 days, 47 days. One of these youth was separately confined for 78 days over an 81-day period. We can move to the next slide, Megan. We examine the conditions of separate confinement with a particular focus on the conditions of separate confinement experienced by youth who were confined for these very long periods of time. And we found that youth who were separately confined were generally housed in a dedicated separate confinement unit, isolated from other youth. That unit currently is called the Independent Observation Unit. We found that youth were not typically locked in a small individual room for 23 hours at a time. They often had access to the day room of the separate confinement unit, but we found that that unit itself is distinctly removed from the regular living units in the center at Burnaby. It is smaller, it's darker, it's less well kept than the regular living units. And for some youth, that unit itself posed a safety risk to youth. It was a space where youth found material, including glass, metal, over and over again to self-injure with. While youth were separately confined, we found that their voluntary social interactions were significantly restricted and minimized. For example, youth were largely restricted from attending school or in participating in programs with other youth. When they were separately confined, they ate their meals alone. They had very little to no contact with family, and they were not provided with cultural, religious, or spiritual supports during those periods of separate confinement. We found that operational and healthcare staff were the separately confined youth's primary source of human interaction, but that this interaction was inconsistent, and it primarily occurred in the course of normal administrative tasks, such as receiving meals, gaining access to washroom facilities, safety check-ins, or really practical logistical conversations. We saw that access to mental health support was inconsistent, and in some cases, it occurred through the meal slot in the door. Moreover, mental health staff were often supportive or recommended the use of separate confinement in response to youth who were self-injuring. And for some youth who were separately confined, we saw that they experienced a repeated use of force by staff, both mechanical and physical uses of force. This also include the forcible removal of clothing. And these measures both diminished youth's sense of autonomy and privacy within the custody center, and it's very likely that they re-traumatized youth who had significant and known histories of trauma. We can move to the next slide, Megan. Okay, I'm gonna discuss a little bit our findings around oversight. So there's a couple mechanisms currently in place that are intended to provide a measure of oversight over the use of separate confinement. First of all, there's some conditions and limits built into the existing regulatory scheme. According to the youth custody regulation, youth can only be separately confined if they pose a risk to health or safety, and no less restrictive alternative are reasonably available. The regulation also provides that separate confinement should continue for no longer than necessary. The regulation also prescribes an escalating decision-making structure for authorizing periods of separate confinement, where longer periods of separate confinement must be authorized by a director of the custody center or the provincial director of youth justice. So under this framework, that first level of oversight over the use of separate confinement is provided by individuals who are responsible for assessing whether separate confinement is necessary in the circumstances. And this oversight is carried out by decision makers within the youth custody centers and by the provincial director of youth justice. We examined these decision-making processes and asked, are they effective at safeguarding against the harms of separate confinement? In our investigation, we found some cases where youth were isolated from other youth without that isolation being recognized or authorized or documented as separate confinement. And because it was not authorized under the regulation, it was not subject then to periodic review by the provincial director. There was no documentation, no formal reviews, and really no oversight over this form of isolation. They occurred without the benefit of the oversight mechanisms that currently exist. Now, we saw this unauthorized separate confinement manifest in two different ways. In some cases, youth at Burnaby were isolated from other youth without any of the required authorization. They were simply moved to the separate confinement unit, the independent observation unit, and housed alone. And in other instances, youth were separately confined in accordance with the policy that provided for isolation of youth for operational reasons, largely because they may have been the only youth at the center, or they were the only female youth at the center. Now, for cases that were authorized as separate confinement that did trigger those review mechanisms that exist in the regulation, we found that this decision-making process did not limit the prolonged and repeated use of separate confinement. It did not prevent the 32 occasions of prolonged separate confinement, and most concerningly, it did not prevent 3 youth who were living with mental illness from being repeatedly separately confined for prolonged periods over 3 years that were the focus of our investigation. Another internal review mechanism is the complaints process. So the ministry is required by law to establish a process for receiving and investigating complaints from youth in custody or from their parents or guardians. This includes complaints from youth about separate confinement or the use of force. And we found that youth who are separately confined rarely use that complaint process that's described in the ministry's policy. Out of the 307 instances of separate confinement, only 9 youth made a complaint. All of these youth were male youth, and none were separately confined for long periods. We found that youth who experienced those long periods of separate confinement did not complain. And this is significant, and we can compare this against youth in the general population who actually make a lot of complaints. For example, in the fiscal year 2016-2017, youth made 805 complaints through that complaints process. The lack of complaints from youth about separate confinement doesn't demonstrate that the youth agree with the decision to separately confine them. Rather, when we reviewed the records, we saw on many occasions youth expressed to staff that they disagreed with their separate confinement, or they were otherwise frustrated or unhappy with their circumstance. The final piece is around inspections. The Provincial Youth Justice Act requires the ministry to establish a process for inspections of youth custody centers on a periodic basis that the minister considers appropriate in the circumstances. Now, in 2011, a memorandum of understanding was entered into between the ministry and the Investigation and Standards Office that establishes that the Investigations and Standards Office will exercise that inspection function that's set out in the Act. But since 2011, when that Memorandum of Understanding came into place, ISO has not conducted any inspections, and we're not aware of any other inspections of youth custody facilities being conducted during this period. So that gives you a sense of some of our key findings. And I'm going to hand it back over to Zoe, who's going to talk about the key recommendations that came out of our investigative work.
Thank you, Sarah. And we can switch it over to the next slide, please, Megan. So in our report, we made 26 recommendations, and they were all directed at the Ministry of Children and Family Development, which is responsible in BC for youth justice programs, including youth custody centers. And so our recommendations are in the broad categories listed here. I'm going to focus in on some of the key recommendations we made. But I want to note just before we go to that, that each of our recommendations contained a timeline for implementation that in our view reflected what we felt was the urgency of needing to address the recommendations that we, or the findings in our investigation. Next slide, please. So as Sarah has described, the existing law is what permits the prolonged separate confinement to happen. So the youth custody regulation requires that separate confinement not continue for longer than necessary. But there's nothing in the regulation that requires the separate confinement to end after a specified period. And there's no cap on the number of consecutive hours or days or number of consecutive times a youth can be separately confined. So the result of this is, as we found in our investigation, that is a decision maker can conscientiously apply the limits in the existing regulation and exercise their discretion and still conclude that the earliest appropriate time for a youth to be released from separate confinement is days or weeks after the initial decision is made, or until they're released into the community. And so our finding as a result of all of that was that the existing regulatory provisions fail to safeguard against the prolonged use of separate confinement and the consequent risk of harm. And we also found that the existing regulatory provisions are inconsistent with the principles of fundamental justice articulated in the Charter of Rights and Freedoms, in the governing principles of the Youth Criminal Justice Act, including Canada's commitments under the United Nations Convention on the Rights of the Child, and the minimum standards of care set out in the Mandela Rules. So one of our key recommendations was to amend the regulation to prohibit the use of separate confinement for more than 22 hours and to limit its repeated use so that a youth could not be separately confined over and over for while they're in custody. We also made a recommendation that separate confinement be prohibited entirely for youth who are particularly vulnerable to its harms. And that would include those under the age of 16 and those with complex mental health needs. And we also recommended that a legal framework be established for youth who, because of the current low numbers of youth in custody in BC right now, are housed alone for operational reasons. And that's particularly female youth who are sometimes the only female youth in custody at a particular time. The ministry does not consider this to be separate confinement, but we found that it meets the test of isolation apart from other youth in a custody center. And so a legal framework is the minimum that's necessary to ensure oversight and to mitigate the harms that it can cause. Next slide, please, Megan. So the second set of key recommendations that we made are around the model of care that is provided to youth in custody. So we identified that the use of separate confinement is inconsistent with commitments that the ministry has made to trauma-informed and culturally safe practices. There's a lack of alternatives. Put simply, staff use separate confinement because it was the only practical option available to them when these youth were in crisis. There's a lack of readily available supports for youth who are really struggling with some complex mental health needs. And so these recommendations are intended to support the implementation of a more trauma-informed and culturally safe approach to the care of youth in custody. So we recommended that the Youth Justice Act be amended to require that all decisions made about Indigenous youth in custody consider their social history. There isn't currently a requirement for that. And secondly, to require youth in custody who have those complex mental health needs to be transferred to a facility that is equipped to provide the care that they need in a trauma-informed and culturally safe way. And more generally, we recommended that within the custody system, that the ministry develop and implement trauma-informed alternatives to separate confinement that maintain and ensure that access to educational, mental health, and cultural supports that is so critical to ensuring that youth are able to do well while they're in a custody setting. Next slide, please. And the final set of recommendations that I'm going to talk about is around the oversight mechanisms. Sarah identified some of the critical issues that with the existing oversight. And I think the broader context to this is that when youth are in custody, they're very far outside of the site of justice. They have few options to assert and advocate for their rights. And responsive and fair oversight mechanisms are really critical to ensuring that if youth are separately confined, it's, as the Youth Criminal Justice Act requires, safe, fair, and humane, and used as absolutely minimally as possible. So we found that the existing processes for reviewing separate confinement, as Sarah described, are not sufficient to safeguard against its overuse or inappropriate use. So thinking about the vulnerability of youth in custody and the risk of harm of separate confinement, we recommended that an independent body be established that reviews, is notified of every separate confinement decision, reviews them, and has the power to end that separate confinement. We also recommended that every use of separate confinement be reported to the representative for children and youth, and where applicable to the public guardian and trustee. So that would be if the PGT is the property guardian of the youth in custody. And we recommended that the ministry complete an independent review of the use of force in youth custody. One of the things that Sarah highlighted about the conditions in separate confinement was that the use of force was a common and repeated experience for some youth. And so the review is intended to identify ways in which the ministry can reduce that. And finally, we recommended that the ministry establish, in accordance with its legislated obligations, regular inspections of youth custody centers, and that it create a framework that is in accordance with the international standards, which are also set out in detail in the Mandela rules. And now I'm going to turn it back over to Jay, who's going to talk about the ministry's response to the report and our next steps.
Thank you, Zoe. Yes, and so hopefully through this, you've had a sense of the investigation we did and the analysis and the recommendations we made. So a little bit about Ombuds process when we are completing an investigation and we're going to make findings and recommendations that potentially adversely affect a public body in terms of having to make administrative changes. Our statute requires that we provide them with notice and the grounds on which we're going to make those findings and recommendations. So we did. We provided a draft report to the ministry for them to provide a response and an indication as to whether they accepted the various recommendations that we were considering. You can, you can see our the ministry's response to our report. It's in Appendix B of the report. The minister acknowledged that separate confinement can be traumatizing and have significant risks for the vulnerable youth who are in custody. And she also said that she found some of our findings to be, in her words, deeply disturbing and painful to read. And I'm encouraged by the minister's commitment to, in her words, endeavor to implement every recommendation in the report. And if you have a chance to look at their reply, after her letter, they do address each of our recommendations one by one. So one of the themes in the ministry's reply is the need for consultation with primarily Indigenous leadership and communities to determine the best way forward. I, of course, agree with that, but I am concerned that the ministry has set out timelines for this work that extend a number of years into the future and don't necessarily reflect the more urgent timelines that we had set out in our recommendation. So while the ministry, has committed to a robust implementation, they're doing so at a more at a slower pace than we thought was appropriate. So, my call has been to them to make this work a priority, recognizing the disproportionate impact that separate confinement has on Indigenous youth. Next slide, please. So we want to see this work as a priority for the ministry. The harms relating to separate confinement should not be ignored, and the ministry isn't ignoring them, but certainly the timelines that they're setting out indicate a lack of urgency that I think is appropriate that they engage in. And there are relatively few youth in custody and in British Columbia and who are being separately confined, and that presents an opportunity for the ministry because of the relatively low custodial counts currently. So we think that they have the time is right for making this change. But we also, I think it's fair to say we saw a dissonance between what the ministry at a high level speaks about a lot, trauma-informed practice, and the lived experience that we saw taking place in the 2 youth custody centers. So we expect to see real changes in the custody system in British Columbia, and our office will be keeping a close eye on what's happening so we can be confident that that change is actually occurring. So how do we do that? Well, it's our practice with all our public reports that we will monitor implementation of the recommendations, and monitoring will involve us collecting information from the ministry about the steps that they've taken to implement each of the recommendations. And We expect the ministry to provide us with relevant and specific information that's verifiable about the various implementation steps for all 26 recommendations. We don't think that a general commitment to act is sufficient, so we'll be monitoring quite closely, and then we'll assess whether in our view, we think that that level of implementation is satisfactory. And as part of that, and as is our practice, we will issue public update reports from time to time on the ministry's implementation. We'll also be keeping a close eye on what's happening in the custody centers in terms of the number of youth separately confined, for how long they're separately confined, and conditions of confinement. So we want to see not just high-level changes, but also expect to see changes on the ground in the custody centers. So I think with that, we'll go to the next slide. And just to remind, as I said at the outset, this is a difficult subject, and as a result of hearing or reading our report or for any other reasons, you need some support. Here are some telephone resources and other ways to get some help. Please reach out if you need some help. Now I'm going to turn it over to Zoe, who's going to pose some questions. If you have questions, please put them in the Q&A, and we'll take some verbally now. We have a few minutes now. We'll take a few now, and if we don't deal with your question now, we're going to be leaving the Q&A open for about 30 minutes afterwards. So we will reply to you. If you can just stay on the line after the webinar ends, we'll reply to each of the questions, even the ones that we don't deal with in the Q&A session. So with that, Zoe.
Thanks, Jay. And the next, can you put it on the next slide, Megan? And that's got our contact information. And you are also welcome to get in contact with us if you have any questions after the session. So maybe we'll start it off with a question about what do you see as the alternatives to separate confinement for youth in custody? It's a practice that has gone on for a long time, and what kind of options are out there?
Thanks. So I think this question comes up too, and people ask, is separate confinement necessary? And I think separate confinement only becomes necessary when we think about behavior management in a custody center really as in a binary. Either a youth is in the general population or they're all alone by themselves. Again, we found that these long periods of separate confinement were in response to youth who were self-injuring and who were experiencing acute mental distress, and isolating these youth away for days, weeks, sometimes months on end is not a solution. Rather, that worsened and deepened their distress. For young people who have complex mental health needs and histories, we need to have a fundamental shift in the way that youth custody responds to them. In other words, and we talk about this in the report, the ministry needs to establish really meaningful alternatives to separate confinement so that youth who are in crisis, there are alternatives that really exist on the ground, are available, and that are implemented. And we identified 3 ways in which the ministry can create these alternatives. One is to really strengthen and fully implement its commitment to trauma-informed practice. It needs to strengthen culturally safe services, particularly for Indigenous youth in custody, and ensure that those youth have access to those services, both as a preventative measure and also when they're in crisis. For example, being able to connect with and have the support of an elder while they're in custody. The ministry also needs to build a legal and a policy framework that ensures youth with complex mental health needs are assessed and transferred out of the custody center into a therapeutic environment where appropriate treatment where they can receive appropriate treatment for their needs. Now, we saw in our investigation a couple of instances where youth who were in distress were certified under the Mental Health Act and moved to a psychiatric facility while they were still within the criminal justice system and in custody. Now, these were for short periods of time, and in most of these cases, youth were housed in the inpatient assessment unit at the Youth Forensic Psychiatric Services site, which is located adjacent to Burnaby. Now, the focus of our investigation was not on assessing the effectiveness of these treatment periods that occurred while youth were certified under the Mental Health Act. It did become apparent after we reviewed the records, after we visited the site and spoke with youth forensic psychiatric staff, that current inpatient assessment unit facility is not adequately equipped to care for youth with complex needs for any extended period of time. For example, those units or rooms were very small. They did not include toilets or sinks or showers. This meant that youth had to be physically restrained and escorted often by custody staff to use the bathroom. We also observed that those rooms in the adjacent site were also vulnerable to damage by youth, and at least on one occasion were a source of self-injuring material. There was also minimal access to secure outdoor space and no sort of common indoor space to facilitate schooling or any other programming. We also found, partly because of the limitations of those sites, that when youth were secluded, that youth in that psychiatric facility were for the most part secluded under physician orders for the majority of time they were housed there. And in most of these instances, seclusion was identified in the youth's care plan with the associated goal of stabilizing the youth. But we saw, in fact, that the social isolation and the lack of stimulation caused by seclusion contributed to a further deterioration of their mental health. In one unique case, we saw a youth transferred to the Maples after a very long period of separate confinement at the Burnaby Center and then seclusion at the adjacent youth forensic site. Now, their time in those places was marked by increasingly risky and violent self-injuring behavior. But in contrast, when they arrived at the Maples, they appeared to quickly stabilize, and they responded very positively to the model of care that was practiced by Maple staff. And that was a model of care that did not include seclusion or further isolation of those youth. So now that's just one instance, but it is a reminder of us to look at the models that exist in British Columbia within the ministry for how we treat or care for youth with complex mental health needs. Thanks, Zoe.
Thanks, Sarah. So the next question is, there's been a lot of work done both within Canada and other jurisdictions and internationally about on the issue of segregation, whether it's in adult corrections. And how do you see your report fitting in with all of this other body of work that has been done on the issue of isolation in custody?
Well, thanks, Zoe. There's been increasing recognition of the harmful effects of prolonged separate confinement in many jurisdictions across Canada, but also internationally. Most of that has been in the adult corrections context. And I'm sure many people will be familiar with, there's been some quite notable litigation that's happened in that context. But recently there has been some focus on youth corrections. We felt that there needed to be more, and that was one of the reasons that we conducted this investigation. But there are some other reports that people may be interested in. There a couple of years ago, there were concurrent reports by both the Manitoba Ombudsman and that province's child and youth advocate that highlighted a number of concerns. And in March of this year, the Alberta Ombudsman released a report called Youth and Segregation, which was the product of their own motion investigation. So, I think that there are a number of initiatives happening in multiple jurisdictions that I think sort of indicate that there is some momentum around addressing this issue on a number of levels. Just the other day, many people will be familiar with the fact that the Senate Committee on Human Rights also released a report with respect to federally sentenced prisoners that included a number of observations with respect to separate confinement or segregation in that system. And there's going to be ongoing evaluation and monitoring of the new system, the new federal system in penitentiary. So number of changes. In addition, there was the important work that was done in Ontario by Howard Sapers that led to some law reform that is mostly not yet enforced, but is another example of that happening, as well as the legislation that happened with respect to the adult correction system in the Yukon that provided for a cap on duration. So I think there's lots of examples currently, and that I certainly think that that's encouraging for the prospects here in BC.
Thanks, Jay. And sort of following on from that, I have another question about whether you think this report will be successful in bringing about change in the youth custody system in BC.
Well, certainly we hope so. And when we make recommendations in a report, our job and our role and our perspective is to try to make principled and practical recommendations that public authorities, that we encourage public authorities to adopt. So the first thing is whether or not they're prepared to publicly commit to those, and pleased to say that that I was encouraged by the response of the minister. And as I said before, the current low counts that are in custody, and some of that is attributable to the pandemic. The provincial court has been using custody less during the pandemic, and that gives the ministry a real opportunity to affect real change at this point in time. We have a number of monitoring tools that are at our disposal, so we'll be utilizing those. And I think that just even in early days, I was encouraged the ministry took immediate steps to further tighten their policy with respect to clothing removal, forcible clothing removal when they deem it appropriate, but now tighter than it was before, and basically life, health, and safety limitations on clothing removal. So that was good to see them do that immediately, and certainly a first step that gives me some optimism. But it's also important to others, for others to, if they think that our recommendations are in the public interest, they can certainly make that known to the ministry as well. When we release these reports, they become public reports, and they're in the hands of everybody. So certainly we'll do what we can through our monitoring and subsequent public reporting, but it's also open to others to reinforce anything that they think is a good idea.
Thanks, Jay. And you sort of, you touched on this already, but do you have any other thoughts on what community groups or advocates could do to support the implementation of the recommendations in this report?
Right. So some 35 years ago, the Supreme Court of Canada, in talking about our role, talked about one of the things that the courts expect an ombuds office to do is to marshal public opinion behind appropriate causes, and certainly the issuing of our public report and things like this webinar are really carrying out that to bring these matters to the attention of people. both the segment of the public who had no idea that about the issues we raised, but also to people who have a good idea and know well and who are involved in this context in the youth justice system. So as I said, it's these matters are public now, and it's certainly open to others to if they think that what we have recommended is in the public interest, to make those views known to government, and the importance of implementation.
Thanks, Jay. So I don't see any other questions right now, but as Jay mentioned, we will be online for some time after this, so you are more than welcome to ask your question in the Q&A, or you can email us at info@bcombudsperson.ca, and we will get back to you. And I just want to say thank you for attending today. And Jay, do you have any last words?
Thank you, Zoe, and just a quick thank you to everybody for taking an hour out of your day. I know that nobody's doing your work while you're listening to this, so I appreciate you committing the time to learning about this. And I would encourage you to read our report. It's available on our website, bcombudsperson.ca, and we'll be posting this webinar in a week or two on our website on the page that relates to this investigation. So if you found it useful and you want to refer others to it, feel free. Anyway, have a great day, everybody. Stay safe.